Well, I suppose my legal background really started when I was in high school, because I formulated the idea in Year 12 that the law was something that I thought I would probably resonate with. I didn't know much about it. I didn't have any members of my family who were lawyers. I didn't know a lawyer. But I thought that it was something that I would like to do. So when I left school, I actually studied law part-time. I worked for the Crown Solicitor for the Commonwealth during the day as a clerk, and went to lectures at law school at night and on some weekends. After I qualified, I worked for the Australian Government Solicitor for a short time. I then worked for the Director of Public Prosecutions, that's the Commonwealth Director, for about 5 years, and practiced in that office in a number of capacities and at a number of different levels. During that time I formulated an aspiration to go to the bar, but I thought I needed to learn some other things, so I went out into private practice for a couple of years and worked in a firm in suburban Sydney, and in 1991 I was admitted to the bar. In 2006 I was appointed Senior Counsel for the State of New South Wales, and in 2011 I was invited by the Chief Justice to take a position on the Supreme Court, and I was sworn in as a judge on the 31st of January 2012. As a judge of the Common Law Division, which is the division in which I sit, we do a variety of cases, both civil and criminal. I do several criminal trials every year. I sit as the bails judge for several weeks a year. I sit in civil cases. I sit in the Court of Criminal Appeal for probably 5 or 6 weeks a year. So the work is very broad. I also sit, as every judge in the Common Law Division does, for a few weeks a year as the duty judge, which means you're on call for 24 hours a day in any given week. At its most fundamental level, the rule of law is essential to any democratic and ordered society. When you break it down, it contains a number of concepts. There are too many to discuss now, but one of the concepts embodied by the rule of law is the notion that everybody is bound by the law, but at the same time everybody is entitled to the benefit of the law. So everybody is bound, for example, by those laws that create criminal offences. But if charged with a criminal offence, everybody has the benefit of the presumption of innocence. And it's those sorts of concepts that the rule of law embodies. And for lawyers, the rule of law is very important, because lawyers uphold the rule of law every single day, particularly those who practice in the criminal jurisdiction, and particularly those who appear for accused persons, because every day in courts throughout the state and throughout the country, lawyers defend the rights of persons charged with criminal offences, and in doing so, those lawyers, very importantly, are upholding the rule of law. Each week, the Supreme Court has a list of bail applications made by accused persons who have been charged with criminal offences and who are awaiting trial. And each application is dealt with in the course of any given day. We hear probably 8 to 10 applications per day. And there are varying kinds, and the charges against those applicants vary quite considerably. The bail laws in this state, without going into too much detail, work on a couple of fundamental bases. The first is that for very serious offences, and in particular circumstances, there is what is called a show cause requirement. So an applicant in that situation, firstly has to show cause why his or her detention is not justified. And in the event that cause is shown, then the court has to engage in an assessment of the risk of allowing a person to be released, and to assess conditions that might be able to be imposed to address any identified risks. If a person is not charged in circumstances which attracts the show cause requirement, then it's a matter for the court to assess the risk and assess conditions which might address those risks. Bail is very difficult, and it's very difficult for a number of reasons. The very concept of keeping a person in custody for a long time awaiting trial in circumstances where that person is entitled to a presumption of innocence, and in circumstances where that person has had nothing proved against them at all, is obviously a very difficult thing for a judge to do. There's a popular misconception in the community that bail is somehow punitive and that it carries a punitive element to it. That's quite wrong. The question that one has to address in determining an application for release on bail involves a number of concepts: the seriousness of the offence, the right of the person to be at large, but it does not carry any punitive concept at all, and that's very important. The media have a very important role to play. My own view is, and my own approach, I suppose, is to cooperate with members of the media to the extent that I possibly can when I'm dealing with a case, because my own personal view, and it's no more than that, is that a collaborative approach ensures that the reporting of a case is going to be accurate. We operate in this country on the basis of a principle of open justice, and that means, subject to the powers of the court being closed, which are exercised only in very limited circumstances, anybody is entitled to come into a courtroom and to watch the proceedings as they're going ahead. And of course, that includes members of the media. But of course, members of the media are under an additional obligation, and their obligation is to ensure that the reporting of a case is both accurate and fair, particularly in criminal trials where there is a jury present. And part of the directions that a trial judge gives a jury at the start of a trial and again at the end is that if the members of the jury see any reporting or hear any reporting or read any reporting of the case, they should ignore it, because the jury, of course, is sworn to return a verdict according to the evidence, not according to any media report. I've been criticised by members of the media from time to time. That is part of the job. There have been occasions on which I've regarded that criticism as wholly unjustified, but people are entitled to express their views. It's part and parcel of the position, and one just moves on. I'm often tempted to answer that question by saying everything, and that would be a truthful answer, because there is no part of this job which is easy. That's hardly surprising, and it would be a little bit odd, frankly, if it was easy. If I were pressed, as I often am, to be a little bit more specific, there are two things, I think. Bail, firstly, for the reason that I explained before, and sentencing is very difficult. The reason that sentencing is very difficult is primarily because so many things have to be taken into account, and having taken them into account, you then have to apply a process of what we call instinctive synthesis to determine what you consider an appropriate sentence to be. And some of the things that you have to take into account are inherently difficult, because you're being asked to project things into the future. For example, one of the things that you have to take into account is the likelihood of a person reoffending. Well, that's obviously very difficult, because you're looking into the unknown. Another thing you have to take into account is a person's prospects of rehabilitation for the same reason. That's very difficult as well. There are also other considerations, obviously the seriousness of the offence and the person's history, whether or not the offence was committed in the home of the victim. They're all very difficult. And of course in the Supreme Court we are dealing mainly in the criminal jurisdiction with two types of offences, murder and terrorism. So both of those obviously are at the very high end of seriousness, and that makes the task, I think, even harder. All cases are memorable in their own way, and in some instances the cases are memorable for very tragic reasons. I did a case back in 2013 which was a murder and which involved the former partner of the deceased, who was only 18 years of age, stomping her to death. And there was evidence in that case that the injuries that were suffered by that young victim were the sort of injuries that you would see as the result of a high-speed motor vehicle accident. Such was their severity. That's memorable, but not in a good way. Don't be disillusioned if people tell you that there is an oversupply of lawyers and that you'll never get a job. And I say that because 43 years ago when I left school, I was told that there were no jobs for lawyers by a vocational guidance counsellor. And I was told that there were a lot of taxi drivers who had law degrees. The inference being that if I chose to study law, I'd end up driving a taxi. Thankfully, that hasn't happened. So the first thing I'd say is don't be disillusioned by being told those sorts of things. There will always be jobs for hard-working, talented, diligent young people. Secondly, these days a law degree can open up opportunities far wider than was the case in past years. When I finished my studies, which is obviously now a long time ago, you would generally finish your studies and follow a traditional path, if you like, by going into practice. And I did that because I had aspirations, or developed aspirations, to become a barrister, and that's what I wanted to do. But these days you can use a law degree in a lot of other positions. I am fairly certain that if you did a survey of senior people in government or senior people in the commercial world, a lot of them would have law degrees, even though they're not practicing. And the reason why they've ended up in those positions is because doing law teaches you analytical skills, it teaches you written communication skills, it teaches you oral communication skills, and all of those skills are transferable. I was at a social function several months ago, and I met somebody who held a very senior position in the entertainment industry. He has a law degree. So it can take you to all sorts of places. And the only other thing I would say is that if you do choose to follow this career, you will need to be prepared to work very hard. It's a challenging career, particularly if you are a litigation lawyer, having the responsibility of dealing with clients and looking after their affairs and protecting their interests is a very onerous responsibility. Be prepared to work hard, but the rewards will be yours if you choose to do that.